All right, good evening, folks. Welcome to. All right, good evening, folks. Welcome to Monday Night Law here with Kirk's Law Corner. Whew, winter is here, at least here in Idaho, and man, I'm hearing from all over the place. Severe weather storms and yeah, lots of snow. Brother Rob, you over here on Telegram tonight? All right, all right. Tigger or Tiger. I don't know which way to pronounce that one, but after the National Assembly call last Thursday, I was pretty confused to feel in order to assemble our state, we need to educate ourselves properly. Imagine that. Knowledge is power. And we'll go to the good book here. See if I can remember where did I have that. Should be this one right here. I've shared this before. No, it's not that one. No, maybe it is. Yeah, well, Hosea, my people are destroyed for lack of knowledge. But that's not the one. Or maybe. Okay, I got lots of bookmarks here. Bear with me. No, that's statutes. All right, what did I do with it? I have to come back here. I'll find it here real quick. But yeah, we've been having a heck of a winter storm here. Streets are all messed up. We've gotten quite a bit of snow and freezing ass cold. 18, I bet it's 1869. Yeah, it should be right here. Yes, here we go. From Ephesians. It was 1869. Yep. So this is Ephesians 1, 18. And all you're getting, above all, get understanding. The Apostle Paul begins the book of Ephesians by telling believers that he is specifically praying that the eyes of your understanding may be opened. He pointed out that if their understanding was opened, then, notice the sequence, then you will know what is the hope of his calling, what are the riches of the glory of his inheritance in the saints. Numerous scriptures affirm this progression. For example, Psalm 119:34 says, "Give me understanding that I may observe your law." Psalm 119:73 similarly declares, "Give me understanding that I may learn your commandments." Because understanding is so crucial, Paul specifically prays for his spiritual son Timothy that the Lord will give you understanding in everything. That's 2 Timothy 2:7. The Bible often groups knowledge, understanding, and wisdom together. For example, Proverbs 24:3 and 4 states, "By wisdom a house is built, and by understanding it is established, and by knowledge the rooms are filled with all precious and pleasant riches." But while the three are often mentioned together, numerous passages affirm that attaining wisdom is the ultimate objective. Significantly, understanding is what takes knowledge and shows how to correctly apply it, thus producing wisdom. So there can't be wisdom, the highest goal, without understanding. So we must gain the knowledge first, comprehend, then understand, stand in agreement, which brings wisdom, a wise dome. So this is where we're at, folks. Knowledge is the key. Knowledge literally empowers us. Without knowledge, we have no power. So, for instance, all political power is inherent in the people. Okay, if you don't have the knowledge of what political power is or who the people are, you have no understanding and you have no wisdom. You must gain the knowledge first, which is part of my mission statement for Kirk's Law Corner LLC. To educate the people on what our rights are, where they come from, and how to effectively claim, exercise, and defend them following due process of law. This is key to all of it. Knowledge. You must know first, then understand it. That now you're empowered. And then you have to learn how to wield that power, which is wisdom. Does that make sense? Ralph, check your messages. I sent you a message to the link to Patreon for the Wednesday night workshop. And just for clarity's sake there, those of you on Patreon, I communicate through Patreon regarding Patreon only, not through private messages, not through Telegram, not anywhere else. Through Patreon only. Patreon is completely separate, okay? Those of you that have subscribed, like Tier 1, Tier 2 to help support, I greatly appreciate that, and that's what I provide here for free every Monday night. There may, like I was saying last week, I may need to do a special video on how do I say this without possibly getting a strike, but our health, let's just put it that way, our health and the health system, and what really, the truth needs to come out, folks. So that needs to be first and foremost, again, knowledge, understanding, and wisdom. But that's going to be a special one. Dang. So who else we got out here? Mark Bond, good to see you, brother. Chad, good to see you, brother. Bruce, I'm not familiar with you, but greetings from South Florida. Lucky you, probably a little bit warm, although haven't you guys been getting some hurricanes and stuff down there? Tornado or hurricanes, right? It's a mess everywhere. James, good to see you back, brother. DJ, Marilyn M. Thank you. Thank you for your comment out there on YouTube, Marilyn. Oh, it's been crazy, let me tell you. Okay, so Leslie, you have to understand there's a difference between a petition and a remonstrance. Petition is a political lawsuit, has a prayer for relief. A remonstrance is a formal written protest, because this is how we protest. Formal written protest in regards to certain legislation in the middle of it being made. Okay? No, we had class Wednesday night. You were there, Scott. Weren't you? Pretty sure you were there. So yeah, there's no such thing called a petition of remonstrance. That was originally what Chris came up with, and since I found this good book here, the one I've been reading from here, Lex Parliamentaria Americana, the law and practice of the legislative assemblies in the United States of America here. This one's the law. Lee, I was reading earlier today about the different jurisdictions, civil and criminal. Wait, the legislature has criminal jurisdiction? Huh. Who'd have thunk? Scott, again, folks, I on Patreon, I sent you a link. It's the same thing every Wednesday night. Same time, same place. Wednesday night workshop is the same time. Wednesday night. It's the same class. Okay? I don't send out notices every week for Wednesday night workshop. I send you one notice in a private message giving you that information. So hopefully that clears that part up. But there's some other issue there from Thursday night call. A little bit of confusion on citizen and inhabitant. Okay, these are our statuses here in America. National not being one of them. Citizen, again, is a public servant. They are a member of the legislative, executive, or judicial who is bound to support the Constitution. That's Article 6, Clause 3. Law of Nations, Book 1, Chapter 19, subsection 212. I read from it on the call. And then the inhabitants are the free inhabitants, to quote the Articles of Confederation, and the free citizens. Now, it talks about a different kind of an inhabitant or a different kind of citizen. Those are the residents, the ones that have declared their intent to settle there. That becomes one of the people. Okay? So there's your three statuses in America: inhabitant, people, and citizen. Citizens are the public servants who are bound by oath or affirmation to support the Constitution. Article 6, Clause 3. The people are the ones that have declared that they're a resident. They intend to stay there. Sometimes referred to as a domicile, but from the Law of Nation is called resident. And then the inhabitants, they don't have any political power because they're not one of the people. All political power is inherent in the people. Not inhabitants, not citizens, not paupers or vagabonds. Okay? The people. You must become one of the people. Now, I know a lot of people, a lot of men and women out there, just hate saying that they're a registered voter. I get it. But that's how you declare that you're a resident. That you're intending to settle here and become one of the people of the territory and claim your political power, your political rights. Because political rights are not natural rights. Okay? It doesn't come naturally. You have to declare that. Other than that, hopefully that clears that up, this confusion between citizen, the people, and inhabitants. No, the people are just called people. All political power is inherent in the people. Use the proper word. They are a different kind of citizen. Okay? And this is before our republican form of government, when that was written in the Law of Nations. So when our founders created our republic, the lowercase c citizen inhabitant became the people. But it even is in the Law of Nations that it says that the body politic is composed of the people themselves. So, that's why we have those three statuses. Inhabitant. But one of the people is still an inhabitant. Okay? Just he's an inhabitant because he's now one of the people because he declared that he's going to settle here. And therefore claims his right of political power, the direct administration of government. Then the elected officials, or those appointed into a position of public trust, are the citizens who receive the emoluments of their offices. They have to perform certain duties. They're bound by the Constitution and subject to its authority, which is the people. Because the Constitution is made by the people themselves. Does that make sense? That's why they are subject. Oh, please do not try to join now. How do I... Where in the heck is it? Maybe it's here. Anyways. No, capital C is citizen, public servant. Man, how come this is so hard to grasp? Citizen, public servant, people, one of the inhabitants of the territory, having political power. They're a resident. Let's just keep it simple. Inhabitant, citizen. Then you add to the inhabitant one of the people. That's a resident, a registered voter. Not everybody registers to vote, so they're just an inhabitant. So say it with me, folks. Inhabitant, people, and citizen. Those are the three statuses right there. That's it. Hopefully that clears that up. Oh boy. Again, with this Article 3 court stuff. Did anybody bother to read Article 3? Article 3 courts are admiralty and maritime jurisdiction. It's what it says as it is written. Read it. Article 3, Section 2. Admiralty and Maritime. Yeah, that was the other thing about being one of the people, is you had to be a business owner, a vested interest, because the people are the ones that pay the bills. How else do you think you pay the governor? How does the governor get paid? Where does that money come from? And it's supposed to be the businesses, the corporations, that pay the taxes. Those taxes pay the emoluments or wages of the public servants. That's why they have political power. And that's why the servants are subject to the authority of the people, because they're the ones that are paying them. All these other funky taxes, sales tax and all, income tax. No, income is profit made off of the labor of somebody else. That's income. Corporations make an income. Yeah, kind of. Ooh, a scammer trying to jump in right here. Right in the middle. Right in the middle of class, a scammer wants to jump in here, huh? Oh, let's see. Okay. I should be looking on Rumble here just in case. Wait, where in the heck is it? And of course, I am now out on X, or formerly known as Twitter. Live on Twitter. I don't know. I actually did see somebody. There was a few people on there last week. No, just go to my home. How do I get on my profile? What the hell is my profile? Is it this one? Yeah, there we go. Well, there's already one heart, one share, and 5 people. But this is only the second time I've gone live on X, so. But I'm going to pick up where we left off last week with the Blackstone's Commentaries on the Law of England. Wanted to say Joseph's story. Got a lot of different people I'm reading from. But, yeah. Yeah, tier 4 is for one-on-ones that people don't want helping them with their court cases and stuff like that. Yeah, I'm not doing any teachings on governmental stuff yet. I tried that through Telegram and doing that on Friday nights, but I can't get people to read and gain the knowledge. Like what I started out with tonight. We got to gain this knowledge. And the reading material is right there in Lex Parliamentaria Americana. The elements of the law and practice of the legislative assemblies in the United States of America. I got one man that did read a little portion of that. The homework assignment was to pick anything out of that whole entire book. Read a section out of there, and then come back and give your dissertation on what you learned. Don't just quote word for word. No. Break it down, what you read and understood, gaining the knowledge here, and share with us, so that what this does is it breaks this large book down in a mass amount of knowledge. If we split it across, 300 people, we had 300 people reading the same book and doing different sections, we can all learn at the same time vicariously through everybody else. And that way it takes this large project for one man like myself to do and splits it across like 300 people. Kind of lightens the load a little bit. But to only get one man to do that just blows my mind. That shows me that there's absolutely zero interest in reading and learning. It's on my website, kirkslawcorner.com, under the library tab. Lex Parliamentaria Americana. There's Mason's Manual, the 2010 edition there. There's Jefferson's Manual in there. But Lex Parliamentaria Americana, that has the whole history of the law, and it is the law and practice of the legislative assemblies in the United States of America. Plain and simple. Sir, do not know any law. Right. uh, well, Scott, when people want to read and share, I mean, I ask people to read from Lex Parliamentaria Americana and post it on the Telegram channels there that I created. Created all 50 state Telegram channels for individuals, and I got a couple people interested. And, I mean, all sorts of people signed up, joined, but no activity. So, I mean, I'm not going to waste my time. Anyways, all right, let's move on to tonight's reading from Blackstone's Commentaries on the Law of England, where we left off last week. So this will be part 4, going over just the part about absolute rights. And there's two main ones, and we're only on the second one. The first one was the right of personal security. Now, the second one is the right of personal liberty, which consists in the power of locomotion. Choo-choo, vroom vroom. Okay? So, without further ado, let's get into that. So we left off here at section 136. And I know I'm just going to back up to this last part so we kind of get a understanding of where we're headed here. So, of great importance to the public is the preservation of this personal liberty. For if once it were left in the power of any, the highest, magistrate to imprison arbitrarily whomever he or his officers thought proper, as in France it is daily practiced by the crown, there would soon be an end of all other rights and immunities. Some have thought that unjust attacks, even upon life or property, at the arbitrary will of the magistrate, are less dangerous to the commonwealth than such as are made upon the personal liberty of the subject. Okay? So, again, I want people to understand that what's being said here is that personal liberty, because it's an absolute right from the laws of nature, from God, this is a very sacred right. And that to deprive life and property is less dangerous than depriving personal liberty, which is also part of the liberty of conscience. To berave a man of life, or by violence to confiscate his estate, without accusation or trial, would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole kingdom. So here you go, folks. Wake up to this despotism, to this tyranny. We no longer have the freedom of locomotion. Got to have a license. Well, if we have to have a driver's license, then that's no longer a right, it's a privilege. Now let's just pose this real quick. How often have you folks been out there, not in your automobile, not on the job working somewhere as a driver, like a, UPS truck driver, a FedEx truck driver, a concrete truck driver, a bus driver, school bus driver, city bus driver, taxi driver. How about even a Domino's pizza delivery driver? How about a Lyft driver, an Uber driver, Pizza Hut delivery driver? Driver. Now, do we get it? How often have you been asked for your ID for a driver's license? Like to go get a cell phone plan. Got a driver's license? What do you need a driver's license to get a cell phone? How about any other interaction with so-called law enforcement out there? Got a driver's license? Got some ID? Why are they asking for a driver's license when you have nothing to do with even being a driver, even if you are a driver, but you're not on the clock? You're not working as a driver. You're not even out on the streets and highways. Why are they asking for a driver's license? Because that's a contract. And you're identifying as a driver. And yes, goal equals jail. I was going to wait to get to there. Diesel D's, you're too good. You jumped the gun. Yeah, how about a limo driver? There you go. I mean, why do they call it a school bus driver, a city bus driver, a truck driver, a taxi driver, a limo driver? Oh, because those are drivers who operate machinery. It's not called driving, it's called operate. And now it becomes a motor vehicle, which is any contrivance used for commercial purposes. Article 1, Section 8, Clause 3. Congress has the power to regulate commerce. Regulate. Supposed to be at the ports. And then I would go so far as saying, okay, once it reaches the port, and then it goes from the port to wherever it's going, say Walmart, McDonald's, whatever, okay, those are drivers who transport those goods to Walmart. So that's in connection with foreign commerce. This is Blackstone's Commentaries on the Law of England. It's in the title of the video. And I'll give a little dissertation on that again, that the reason why I'm reading through this book is because the New York State Rifle Pistol Association versus Bruin case, June of 2022, the Supreme Court of the United States referred to this right here. That upper section there of the absolute right of personal security, as they said on the right to keep and bear arms, actually comes from, and they cited right here from Blackstone's Commentaries on the Law of England, is the right from nature, would be the law of nature, as the fundamental right of self-defense. So this is what triggered me to actually go back and read this, which, again, I've already had this for quite some time. I just never got around to reading it. Number one is because I'm thinking Blackstone. Well, that's, a common law of England. Well, there again, reading means reading. Lo and behold, there is some very good stuff in here. And Blackstone in these writings here, he covers both the English common law and the American common law. See, a lot of people don't even understand that there is a difference between the English common law and the American common law. But I digress. So, I'm sounding the alarm, folks, of tyranny throughout the whole kingdom. But again, we have to gain this knowledge. And that's why I'm hammering this stuff out. This is like grassroots, the root of it all. The laws of nature here is what we're actually, these absolute rights come from the law of nature. And we need to fully comprehend, then understand this, that these are absolute rights. And we need to call it out. But confinement of the person by secretly hurrying him to jail, Old English, Gaol, kind of like policy, which we pronounce as police today. That's Old English for policy, Police, policy, 3-syllable word, not a 2. I don't know how people get police. There's no lease there. Lease. No, there's a CE. Policy. But hey, in modern English, it's spelt with a Y. That's trickery. Oh, Jerry over here on YouTube. No, we don't have income, we have outgoings. No. We have the right to contract our labor as we see fit. And we are entitled to the entire fruits of our labor. It's fruits of our labor. And it's the right to contract. Our right to contract is unlimited. That's true, real capitalism. It doesn't have anything to do with government. What we do in the private is a private contract between me and my neighbor to paint his house. Has nothing to do with the government. Because inhabitants and the people are in the private. Public servants are in the public. Corporations are in law with a business license. They incorporate into the body politic. Now they're subject to particular statutes regarding their business license. Okay. Hurry him to jail, where his sufferings are unknown and forgotten, is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. How many of you have been out there, have been unlawfully arrested and taken to jail when due process of law requires that the executive branch takes us to the judicial branch for oversight? I mean, this is as old as the Magna Carta. Let me pull that over here real quick and just show you, even though this isn't proper verbiage, as they have modified this even since I started showing it. It used to say, to no man will we sell, to no man will we deny or delay right or justice. Hey, what's the Aziz? You know, Aziz of Clarendon? A court, usually but not always, consisting of 12 men. The Aziz of Clarendon of 1166 is the actual origin of the right to trial by jury of 12 men. Just saying, that's how old that right is. So, number 38 is very key to understanding of what has been going on again. No bailiff for the future shall, upon his own unsupported complaint, put anyone to his law without credible witnesses brought for this purposes. So, those are the prosecutions by information, where like a police officer out there pulls you over, makes an arrest, and gives you a... because that's an arrest. It's an arrest of your personal liberty. For a traffic infraction, which are bills of attainder, bills of pains and penalties. And then sometimes they'll try to turn it into other things. Well, I'm going to search your car. Oh, you can't have that. Well, that's a crime. And then they turn a traffic stop into criminal, but it's an unsupported complaint. Where's the accuser? Where's the injured party? Again, this is as old as the Magna Carta. Again, folks. You think this is the first time in history we've been subjected to this crap? No. This is the same crap from clear back in 400 AD. 600 AD. Then again, when it got brought back up and found in 1130 AD at Amalfi, and then that usurper Stephen, King Stephen, who got in there in 1135 and brought back the Roman civil law, the code, which is all enforced through bills of pains and penalties. And then the next one, 39. No free man shall be taken or prisoner, diseased, or exiled, in any way destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers. That'd be that grand jury indictment. Or by the law of the land. Not by statutes. And most certainly not by the code. Not by regulations. By the law of the land. You know, supreme law of the land, law of the land. That's your state and federal constitutions there. And why is it called the supreme law of the land? Because it's supreme. Anything that comes in conflict with that's void for any effect. Article 6, Clause 2. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary are notwithstanding. Then Marbury versus Madison backs that up. Anything that comes in conflict with the supreme law of the land is void for any effect from its inception, void ab initio. Now, section 40, chapter 40. Now they say to know one. One what? No, it's to no man will we sell. To no man will we refuse or delay right or justice. It used to be deny or delay right or justice. So these three right here are crucial to knowledge, gain the understanding of what they mean and what they meant at the time that it was written, and apply it to today's timing. Because if it was a limitation on the king in 1215, it most certainly is a limitation on our government today in 2024. Does that make sense? Well, to you, Diesel D's, thank you, brother. One of my star students out there. Yep. So, most of y'all been to jail from all this stuff because, well, what did you do about it? I made a vow to God in 1995, sitting in the jail cell, that I'd start studying law, and so that wouldn't happen to me again. But again, where I started in the code. I didn't know. So I learned a lot of the code stuff, and then I got in, of course, Constitution. But I never thought to read the Idaho Constitution. Whoa, lo and behold, there's some good stuff in there. But even the Idaho Constitution's a fraud. Now that I've found in the Idaho legislative sessions, it's all garbage. None of it was ever submitted to Congress after 1873, 1874. Congress said, oh, Idaho, Montana, Dakota, Wyoming, and Colorado, don't worry about it. Don't have to send anything in for approval or rejection from Congress, even though Article 4, Section 3 requires us to do that. Well, we're not going to require that now. You guys can just make whatever you want. And that's how we ended up with the Idaho Code in the 11th legislative session for the territory of Idaho, before our so-called Constitution in 1890, which was never submitted to Congress for approval to guarantee that Republican form of government. In the 11th legislative session, that Code of Civil Procedure Act. And it says that the rule of common law, that statutes and derogation thereof does not apply, and the code is the law. Well, this is what I just tried to explain Thursday night on the National Assembly call. Okay, the code as a fundamental law is the Roman civil law. It is opposed. It is opposed to the law of nations, the laws of nature, and the common law. It's a totally different jurisdiction, a different body of law as a fundamental law. Okay? So, there it is. Right from the Magna Carta. Basically, no prosecutions by information on a police officer. And no man can be deprived of their rights. You can't be imprisoned, destroyed, or they can't even come upon us without a warrant. And they have to follow the law of the land. Must be a lawful judgment of his peers or by the law of the land. That's your two choices. So kick these statutes code to the curb on several different counts and reasons. The fact is, we got to be following the law of the land if you're going to deprive life, liberty, property, pursuit of happiness here. You have to follow the law of the land. Okay? You know, this is what he's talking about here, Joseph's story. That's what he's talking about here. You know, go back up here to the footnotes, which ties right into what I just read there. The words law of the land and due process of law are employed interchangeably in constitutional law and mean the same thing. So when we say law of the land, we're actually saying due process of law. And back to American Jurisprudence, Volume 16, Constitutional Law, Section 100, 2017 update. So this isn't old stuff, right? This is fairly new. The Bills of Rights and those merely declaratory of the common law. Oh, that's right. The Bill of Rights is just merely declaratory of the common law. It's already the law. It's already due process of law. And to really throw people for a loop, law of the land is short for common law of the land. So when we look at Bills of Rights, those rights that are enumerated in there, specifically the ones for the states, those are just merely declaratory of the common law. Already the law, long antecedent the formation of the state, to cite Hale versus Hinkle. Long before. Clear all the way back to the Magna Carta 1215, or even to the Aziz of Clarendon of 1166 regarding the right to a trial by jury, Aziz of 12 men. I mean, we're talking 800 plus years ago, folks. How do we not know this today, 800 years later? Aside from the obvious, we've been purposely dumbed down. They didn't teach us this stuff. So, here we are. Sitting here with me on Monday night, learning the law, what we were supposed to have learned. You know, again, I just recently found a video on YouTube. There was a statute that they were taking down of General Lee. And underneath the statute, they found a time capsule box in there. They cut that thing open, and they were going through there some documents and books and stuff in there, and lo and behold, there's fourth grade educational material teaching fourth graders the law. Fourth grade, folks. Does it make you feel really stupid? Kind of does me too. Because I'm looking back at where I was at in fourth grade going, wow, can you imagine being taught the law stuff in fourth grade? For those of that you can possibly remember fourth grade, go back to that time period. Think about that for a minute. I mean, for me, I remember, you know, first grade was like writing, and second grade was a little more writing, and then we got into language and vocabulary, and third grade spelling, you know, and then by fourth grade, we're supposed to kind of have this basic knowledge of stuff. I mean, they even have a show out there now called Are You Smart as a Fifth Grader? Well, let's compare a fifth grader today to, say, a fifth grader from 1776. I'll tell you what, that fifth grader from 1776 would smoke a high school student in today's timing. Plain and simple. Our high school students of today a lot of them, like 60% of them, can't even frickin' read, let alone comprehend what they do read. Well, obviously, if they can't read, they're not going to be able to comprehend. So, there's our problem. On purpose, right? Make no mistake, it was done on purpose. All right. Back to Blackstone's Commentaries on the Law of England. Under Section 136, under absolute rights of individuals, this particular absolute right is the right of personal liberty. And this cannot be deprived without following the law of the land. These are absolute rights. And so again, I'm sounding the alarm of tyranny, of this arbitrary government. And I'm explaining why it's this way. Because they switched us from the fundamental law of the common law, the laws of nature and the law of nations, over to Roman civil law, the code. The code becomes the law. They don't care about the Constitution. See, when you're talking Roman civil law, you have civil rights, which are actually privileges that are granted to us by the king. And only those privileges, like a license, like a business license, for those seriously in the private, why would you need a business license? Why would you need to seek permission to contract your labor? Doesn't make any sense, does it? If our right to contract is unlimited, then why do we need to get a business license? Why do we need permission? Just exactly from who? Do I need permission from my neighbor? Then it's unlawful. But the root of the problem is the fundamental law has been changed. It subverts our God-given natural rights and replaces them with civil rights from the Roman civil law, again, which are privileges. And those privileges are granted through licenses. And again, you only have those that the king gives you, that dictates that we have. Okay, and yet sometimes when the state is in real danger, even this may be a necessary measure. But the happiness of our Constitution is that it is not left to the executive power to determine when the danger of the state is so great as to render this measure expedient, for it is the Parliament only, or legislative power only, that whenever it sees proper, can authorize the Crown by suspending the Habeas Corpus Act for the short and limited time to imprison suspected persons without giving any reason for so doing. Now, those of you that didn't watch last week and where it was talking above there about the habeas corpus, and it's in the Constitution where the habeas corpus, the right of habeas corpus can be suspended if you're involved in the military in time of war, in actual line of duty, and you do something, you can get arrested and thrown in jail, or you're engaged in rebellion. Okay? But that has to be done and declared by the legislative branch, not the executive. And clearly it wouldn't be anything to do with the judicial. So, I mean, this is Blackstone's Commentaries on the Law of England from 1780 something, if I remember right. You know, I just, we're in bad shape, folks. We really must gain this knowledge. without giving any reason for doing so, as the Senate of Rome was wont to have recourse to a dictator, a magistrate of absolute authority, when they judged the republic in any imminent danger. The decree of the Senate, which usually preceded the nomination of this magistrate. Now here we go. He's citing maxims of law. And it's written in Latin, so a little bit of a disadvantage here unless I pull that out and plug it in and have it translated for me. Where's my Latin reading, folks? There's got to be one or two of you out here, right? Dent operum consuls nequed replica. Yeah. Was called the Senatus Consultum Ultimate Necessitas. So out of the necessity of the Senate, consult with the Senate. Something like that. I can get some of it. So, in like manner, this experiment ought only to be tried in cases of extreme emergency. And in these, the nation parts with its liberty for a while in order to preserve it forever. So, this emergency stuff is for enemy attack, either foreign invasion, enemy attack, not for a communicable disease. Again, this goes back to that other video I need to do. Plain and simple. A state of emergency is for enemy attack. Not for anything else. To declare war, right? That's right. To be declared war for a communicable disease? Oh, I'm getting sick. Oh, that's it. We're at war. No, that's not how that works. That would be unlawful. And again, it was declared by executive branch. What was just said there? That's a legislative power only. So, 49 governors usurped their powers. That's right. I called my governor out on it, pursuant to Article 4, Section 9 of the Idaho Constitution. Sure, he can do a proclamation, but he must call the legislature in to deal with that so-called state of emergency. But here, technically speaking, lawfully speaking, historically speaking, no, the executive branch cannot do that. That belongs to the legislature only. So, those of you out there that are wanting to get involved with reassembling government de jure, remember this part of Blackstone's Commentaries on the Law of England and what the power is of the legislature to declare a state of emergency, not the executive. The confinement of the person in any wise, or any way, is an imprisonment. Okay, treatise on arrest and false imprisonment. Okay, it's not treatise on false arrest and false imprisonment. It's treatise on arrest. Okay, it lays out the law and the history, even case law, behind what an arrest can be made for. Without a warrant specifically. Okay, which is felonies and breaches of the peace, which is assaults and batteries, and only goes so far as stopping the breach of peace. They can't put handcuffs on you. An arrest just means to stop. So that's the thing. The second they use their emergency lights, they're making an arrest of your personal liberty. They must articulate the crime unless you're an actual driver and you submit to the personal jurisdiction because you're employed as a driver to operate a motor vehicle in foreign or interstate commerce. Now, your contract of employment is what binds you to pull over for traffic infractions. But then you can even fight those because those are bills of attainder. It would be administrative, which doesn't have, supposed to be an Anisi Prius court. That would be a Department of Transportation court, a Anisi Prius court, which would not have the authority to fine or incarcerate. Things like points on your record, driving record. Like, if you get more than 12 points within a year, your license can get suspended because you're proving that you're not safe to be out on the streets and highways as a driver operating a motor vehicle. That's for the inhabitants' necessary security and safety, that we keep the roads safe for us. So, again, the confinement of the person in any ways, is an imprisonment, so that the keeping a man against his will in a private house, putting him in the stocks, arresting or forcibly detaining him in the street is an imprisonment. Treatise on arrest and false imprisonment. Hey, you, stop. That is an arrest. That is the second you say, now. And then he puts his hands on you. Now it's forcibly. That becomes battery. And if he's wearing arms, that becomes aggravated battery. That's a breach of the peace. And see, they like to use, well, I'm just detaining you. I'm detaining you. Detain and arrest are synonymous. You have no lawful authority to walk up to a man and say, hey, you, stop. Unless you're about to articulate the crime that you're placing him under arrest for. Which it damn well better be a felony happening directly in front of him, or made aware of a felony, or breaches of the peace, either assault or battery. But like treatise on arrest and false imprisonment lays out, if the breach of peace, like say a bar fight, okay, and two guys are getting into it, the cops are called. Well, due to response time, the fight's already over, and the two guys that were fighting are sitting up at the bar having a drink because now they're best friends. And the police show up and say, oh, hey, well, yeah, we duked it out, but we're friends now. Oh, well, you're under arrest. No. The breach of the peace is over, and neither one of us want to file charges against one another. Okay. Bye. Now, I can tell you right now, I've personally been through something like that. Came to the aid and defense of a friend of mine, and her ex-husband there was being a douchebag and threatening her and wanted me to come out there and help defend her, so because he wouldn't leave. Well, he decided he thought he was going to sneak around the corner there where we were standing and pepper spray me directly point blank range right in my eyeball. Well, my little Marine Corps instincts kicked in, and I got a hold of him and basically beat the crap out of him down to the floor, and he crawled away like a little schoolgirl, screaming and hollering how I was going to kill him. Crawled in under his bed in the bedroom there, calling the police, and while I'm outside there at the hose bib trying to wash this shit off my face because I couldn't see. And when the cops got there, they actually put me in cuffs at first, but, in the end of it, they asked me, well, do you want to press charges against him? I could have said yeah, but I said no. I think he got his little beat down. He got what he deserved there to a certain extent. Not only that, he had to face what he was trying to do to her. And I thought, well, that'll be enough. So I know for a fact that that's how that works. Got to have the accuser. You don't have the state's going to go ahead and pick up the chart. No. The state can't pick up any charges because you got to have the accuser. If I don't press the charges, you don't got a witness. You don't have an accuser. You don't have an injured party. Who's going to take the stand and accuse that man of what he did? So, oh, sorry, corruption detector. Good to see you, brother. Saying that Telegram's feed is being really choppy. Well, bad weather all over the place, brother. I know Marka, she's out there in New Jersey talking about her internet's been in and out due to weather. Power's been in and out. So, maybe on a replay. Yeah. I agree with Mark out there. The Treatise on Arrest and False Imprisonment by Charles Wiseman. That's my number one go-to. People ask, well, where should I start? What should I read? Right there, Treatise on Arrest and False Imprisonment. Okay? To get yourself started, you're totally new. Maybe even if you've been studying for a while and you've never heard anything about Treatise on Arrest and False Imprisonment, I recommend reading it. It's on my library tab on kirkslawcorner.com as the number one book. That's why I put it first. If you're going to start somewhere, start there. Because a lot of this stuff that we're talking about right now, right here from Blackstone's, is in that book with lots of case law. And I'll be darned, it's in the form of a summons, a complaint, and a memorandum of law. Document templates right in the book, folks. So even detaining him in the street is an imprisonment. And the law so much discourages unlawful confinement that if a man is under duress of imprisonment, which we before explained to mean a compulsion by an illegal restraint of liberty until he seals a bond or the like, he may allege this duress and avoid the extorted bond. But if we actually go back up and then we look at that John Bad Elk, well, that's weird. I don't know how it was 40 minutes of delay when I'm sitting here using it. Okay. What was I saying? Oh, yeah, the John Bad Elk versus United States case, where the man took out his weapon and defended himself. They didn't have a warrant. Shot and killed those two officers, sheriff deputies. They went to put his hands on him. He defended himself. That comes right from the laws of nature, the right of self-defense. Now, they want us to lead us to believe that, well, we can't do that. BS. Here in America, that's why the right of the people to keep and bear arms shall not be infringed, so that we can defend ourselves from tyranny. And I really think that is where Supreme Court is hinting at us. And it's not even the Supreme Court anymore. Again, there's another case out of California that the federal district court struck down California legislation requiring people to get concealed weapons permits. Nope, nope. Legislature, you don't have that authority. That right shall not be infringed. Damn it. Why doesn't somebody ask the question? Well, do they have legislative subject matter jurisdiction to begin with? Do they have personal who are you making legislation for? It can't apply to the people. The people have all the power. You're the servants. Why are servants trying to dictate to their masters what our rights are and how we claim and exercise them? Well, we can regulate. No, you cannot regulate a right. Then it's not a right. And then one of the rights we're talking about here is an absolute right. The right of self-defense, the right of personal security. The right of self-defense. It's one of the 6 primitive laws of nature. The right of self-defense. Come on. It's at the root of just about all law ever, anywhere. First, that's why did they start the right of personal security? The right of self-defense. The number 1 absolute right is the right of self-defense. The number 2 right, absolute right, is the right of personal liberty. I mean, we cannot go any more deep than these 2 absolute rights. Now, anything that comes in conflict with this clearly is void for any effect. Because that's how that works. Hierarchy. Which stands on a higher plane? Our rights or the Constitution? Our rights or a statute? Our rights or a code or a regulation or a city ordinance? Come on, folks. Which one stands on a higher plane? What I mean by higher plane, hierarchy. Remember, government is instituted to secure these rights. That is the whole intent of creating government to begin with. Hale versus Hinkle. Our rights are long antecedent to the formation of the state. Our rights pre-exist creating government. And then again, the intent of creating government is to secure these rights. So again, they have to exist before we institute a government. And that's why those bills of rights and those merely declaratory of the common law, those are part of the common law of the land, and those provisions are mandatory. 4th, 5th, and 6th, they are mandatory. There is no delegation of legislative authority there, like the so-called fraudulent 14th Amendment. Oh, and Congress shall have the power to make legislation. See, I'm going to show that right now, just because. People need to see this. What I'm talking about, that verbiage there, that's not there in the Bill of Rights. The Congress shall have power to enforce by appropriate legislation the provisions of this article. This is a delegation of legislative authority. Subject matter jurisdiction. Now, I decided not to go. I don't see that here. I don't see a delegation of authority here. Where's that verbiage? The Congress shall have the authority to make appropriate legislation. regarding this subject. It's not there. Therefore, there's no authority. None. Zero. No delegation of authority. It's a Bill of Rights. The fifth. No person shall be held to answer for a capital otherwise infamous crime unless on presentment or indictment of a grand jury. Oh. Wait a minute. Where does that say information? Uh-oh. That's right. You got to have a grant. That's due process of law. This is merely declaratory of the common law. Law of the land, due process of law, common law of the land, due process of law here. This is the process. It dictates that you must get a grand jury indictment for crimes. So anything that comes in conflict with this, whether it's in the Constitution or laws of a state, to the contrary, is notwithstanding. Oh, but Kirk, the Bill of Rights doesn't apply to the states except for by and through the 14th. Hogwash. This is just merely declaratory of the common law. This even goes clear back to the Magna Carta 1215, chapter 65. Grand jury indictments. 1215. 800 plus years ago. Now, there's an exception to this. Except in cases arising in land or naval forces or in the militia when in actual service in time of war or public danger. Now, that's when the right to writ of habeas corpus can be suspended. That's the exception to the writ of habeas corpus right there, which Blackstone's Commentaries on the Law of England was just talking about. And then here's the double jeopardy clause. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Due process of law clause is the Fifth Amendment, not the 14th. Are we going to say that we didn't have the right to due process of law until 1868? Are you frickin' kidding me? It's right here in writing. And it's not the Fifth Amendment. It's Article the Fifth, because the original Bill of Rights says articles in addition to an amendment. That's right. The Bill of Rights was an amendment to the Constitution. And they are articles, which under contract law, that's how contracts are written, in articles. But see, all throughout history, Bills of Rights were actually done first, then the Constitution, because that's the instrument of government to secure these rights. And rights are the law, common law, and that to secure these rights, governments are instituted. The Constitution is the conscience of government. The mind control. To control the minds of the president. To control the mind of the governor. Those persons that are created by the Constitution. A conscience. By the people, by the way. And then the sixth article of the Bill of Rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. And listen carefully, folks, for those out there in the back that have a hard time with this. District wherein the crime shall have been committed. That is territorial jurisdiction. which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, which means you gotta have an accuser, and is it criminal in nature or civil in nature? Okay? To be confronted with the witnesses against him. Now, see, Virginia Declaration of Rights, June 12, 1776, says to be confronted with the accuser and witnesses against him. So see how they kind of subverted that, leaving that out of there? There's some trickery that was going on here at this particular point in time, folks. And to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. See, where does it say to have a member of the bar represent? No. It says assistance of counsel for his defense. But again, where does it say Congress has the authority? Oh. Well, they don't. Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. Generally, due process guarantees protect individual rights by limiting the exercise of government power. The Supreme Court has held that the Fifth Amendment, which applies to federal government action, provides persons with both procedural and substantive due process guarantees. Now, like substantive, okay, this is where the legislature makes something that subverts due process of law, or violates a right, takes away a right, or regulates a right. This is legislation making when we're talking about substantive due process. If the federal government seeks to deprive a person of protected life, liberty, or interest, the due process clause requires that the government first provide certain procedural protections. Where's the one? Requires the government to provide a person with notice and opportunity for a hearing before such deprivation. Uh-oh. Remember, how many times have you heard me say, oh yeah, the first fundamental principle of due process of law is notice and opportunity? There it is. Right there on the screen right now. Notice and opportunity for a hearing. The right to be heard. Before such deprivation. That would be pursuant to the law of the land, Fifth Amendment, or Article the 5th. Such as liberty of contract, marriage, or privacy. This is that subject matter jurisdiction is really what substantive due process is. Did they actually have subject matter jurisdiction? Like the right to keep and bear arms shall not be infringed? No, they don't have. So it doesn't meet substantive due process. Due process protects all persons within the territory, including corporations, aliens, and presumptively citizens seeking readmission to the United States. However, the states are not entitled to due process protections against the federal government. Since when? Oh, since 1966 in this South Carolina versus Ketsejaba. No. The clause is effective in the District of Columbia and in territories that are part of the United States, but it does not apply in its own force to unincorporated territories, nor does it reach enemy alien belligerents tried by military tribunals outside the territorial jurisdiction of the United States. The clause restrains Congress in addition to the executive and judicial branches and cannot be so construed as to leave Congress free to make any process, due process of law by enacting legislation to that effect. It should be Murray's Lizzie versus Hoboken Land and Improvement Company. It was manifest that it was not left to Congress to make any process, due process of law. That's because they don't have subject matter jurisdiction. We didn't give them jurisdiction over our rights. It's a Bill of Rights declaring it, laying it down, but it was already the law prior to. They're still trying really hard to say that this only applies to the federal government. Really? I find that hard to believe given the verbiage of both the 9th and the 10th. Because, I don't know, this just doesn't make any sense if the Bill of Rights doesn't apply to the states. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. They're trying to deny the Fifth Amendment to begin with. But why does it say the enumeration in the Constitution? Wait. What Constitution? Of certain rights. It's part of the Bill of Rights. We've been lied to. That's why we need to read the original verbiage of the original Bill of Rights, which says these are articles in addition to an amendment to the Constitution. So, yes, it most certainly does apply to the states. Or you're attempting to deny them. In direct violation of the 9th. But then let's read the 10th again. The powers not delegated to the United States by there we go again, by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. How can this not apply to the states? It's part of the Constitution. Both the 9th and the 10th mention the Constitution. Does the rest of the Constitution apply to the states? Yes, it most certainly does. And these happen to be rights as the law. So, yes, it most certainly does apply to the states. Because Article 4, Section 3 and Article 4, Section 4 to guarantee a Republican form of government, Article 4, Section 3 to admit new states into the Union to ensure that their constitutions and laws of the territories, states, are in compliance with the supreme law of the land. Right. That's how that works. We're being deceived because we lack the knowledge. Plain and simple. They're trying to say that we're 14th Amendment citizens, which have privileges, not rights. Sorry, wrong answer. Not only that, basically everything since 1861 on is void for any effect, for fraud. Another bankers' civil war, supposedly about slavery. Well, it was about slavery. It was about enslaving us all. Because if you actually read the 14th Amendment, what it says, which I just closed that down, but we have privileges. It doesn't say we have rights. And then what did it say? Oh, in the end, Congress has the authority to make legislation. Yeah. No. No, and no. And I have congressional record on where they talk about the unlawful 14th Amendment. It was not ratified. In fact, the several states that did respond said no. So it's void. Just on those grounds. But hey, reading means reading. All right. We didn't get very far tonight, did we? But that's okay. We got about 20 more minutes here. But if a man be lawfully imprisoned, and either to procure his discharge or on any other fair account, seals a bond or a deed, this is not by duress of imprisonment, and he is not at liberty to avoid it. To make imprisonment lawful, it must either be by process from the courts of judicature or by warrant from some legal officer having authority to commit to prison, which warrant must be in writing, under the hand and seal of the magistrate, and express the cause of the commitment, in order to be examined into, if necessary, upon a habeas corpus. Now, that's what habeas corpus is really about. Bring the body, bring your papers, and you better be able to prove why you have this man imprisoned. And it better be lawful. You better have followed the law of the land. But that's what you put in the habeas corpus. It wasn't lawful what they did. And now the burden of proof shifts to them. And this is an immediate remedy to get the relief to be released. And this is supposed to be filed in the Supreme Court of your state. If there be no cause expressed, the jailer is not bound to detain the prisoner. For the law judges, in this respect, said Sir Edward Coke, like Festus, the Roman governor, that it is unreasonable to send a prisoner and not to signify withal the crimes alleged against him. Whew. Where's the accuser? Where's the crimes? Where's it under oath? Because the Fourth Amendment requires that. Bound by oath or affirmation. Has to be supported by. And it can't be done by the police officer. That's Magna Carta, chapter 38. So a natural and regular consequence of this personal liberty is that every Englishman may claim a right to abide in his own country so long as he pleases, and not to be driven from it unless by the sentence of the law. The king, indeed, by his royal prerogative, may issue out his writ ex regnum, and prohibit any of his subjects from going into foreign parts without license. Sound familiar? This may be necessary for the public service and safeguard of the Commonwealth, but no power on earth, except the authority of Parliament, can send any subject of England out of the land against his will. No, not even a criminal. For exile and transportation are are punishments at present unknown to the common law. That's right. It doesn't exist at common law. Uh-oh. But under Roman civil law it does. But not under the common law it does. Choice of law. And whenever the latter is now inflicted, it is either by the choice of the criminal himself to escape a capital punishment, or else by the express direction of some modern act of Parliament. Legislative branch, not judicial, not executive. To this purpose, the Great Charter, Magna Carta, declares that no free man See, look, that no free man shall be banished unless by the judgment of his peers or by the law of the land. Now, why doesn't it say over there earlier, why doesn't it say man? So, here, clearly, he's talking about that. Chapter 29. Because that's what P. First to chapter 29. I wonder what year. Well, this would be later down the road because there's a couple different revisions of the Magna Carta. What was it? 1227, I believe it was, and 1229 was the third revision. So I'd have to figure out what year he's actually referring to that would be chapter 29. Because we were just reading that. That was 39. Oh, we got to finish reading that. And by the Habeas Corpus Act, 31 Car, which I guess Rob figured that out as Charles II. Chapter 2, that second Magna Carta and stable bulwark of our liberties. It is enacted that no subject of this realm who is an inhabitant of England, Wales, or Berwick shall be sent prisoner into Scotland, Ireland, Jersey, Guernsey, or places beyond the seas where they cannot have the full benefit and protection of the common law. But that all such imprisonments shall be illegal. That the person who shall dare to commit another contrary to this law shall be disabled from bearing any office, shall incur the penalty of a manure, and be incapable of receiving the king's pardon. Ooh. So see, these are grounds for removal from office. And the party suffering shall also have his private action against the person committing, and all his aiders, advisors, and abettors. See, this would be a suit at common law suits between man and man, which would be criminal in nature. Oh, but you guys can't. No, the people can't prosecute. Rob, are you saying Article 29 says that in Magna Carta? Well, let's go to 29. No constable shall compel any knight to give money in lieu of castle guard when he is willing to perform his own person. No. 29 doesn't say that. Thirty-nine. No free man shall be taken or imprisoned, or diseased, or exiled in any way, destroyed, nor will we go upon him or send upon him, except by the lawful judgment as appears by the law of the land. 39. But again, there's different revisions. Yeah. I'd be interested to see what year that one is. As I may have, obviously rewritten this a few times. Amended, I should say. So, So here's a good one out there for some of them farmers out there where they've had these jack wagons out there stealing their milk or destroying whatever. No constable or other bailiff of ours shall take corn or other provisions from anyone without immediately tendering money therefore, unless he can have postponement thereof by permission of the seller. No, that is not chapter 29 of the Magna Carta of 1215. I just read chapter 29. It's right here. No constable shall compel any knight to give money in lieu. It doesn't say that. It is chapter 39 that says that of 1215. Again, you're reading a different revision of the 1215 Magna Carta. There's the 1227, the 1229. It's on the screen right now. It is chapter 39 of the Magna Carta of 1215. Not 29. 39 of the 1215. And I can't pull that. I don't think I can. I'm going to try. Control C. Let's see if that happens. Oh, it did. Let's see if that works. Okay, but this is not 1215. I can tell you that right now. Because... yeah, see? This is not 1215. Not only that, it only goes to Article 48. Where's Article 65? This is not a 1215 Magna Carta. Although they say Articles of the Barons 1215, this would be 1992. There's different revisions of the 1215. So this is, I'm not sure what year it is, but it's not correct. If it's saying it's the actual 1215, it's not. These are different. This is definitely a different revision. Because clearly 29 does not say of 1215, the actual 1215 Magna Carta, does not say what 39 says and what it's supposed to say. Because see, look, when we go down here, oh, what's this? It's well past 48. Oh, it was chapter 60. Is it chapter 61? Maybe it is. It is chapter 61 of the Magna Carta for the grand jury. Yep, right here. Of 5 and 20 barons for the execution of all the aforesaid matters, and along with them to molest us to the utmost his power. This is the origin of the grand jury right here. 25, 5 and 20. And that's chapter 61 of the 1215 Magna Carta, which supposedly this one is, only goes to chapter 48. There is no chapter 61. So there's the problem. That would be an improper citation. But, anywho. All right. So where are we leaving off? 137. Actually, 138. We'll stop at 138. Oh. Well, I suppose I should go back to that. Come on. Let me have it. Oh, I'm going to have to share. I think. Well, everybody should be able to see this, right? All right, so, oh yeah, I wanted to thank Miles, who's my website guy here. Made some updates on here. He put my X, Twitter, whatever, link here. So this is all the platforms right now, social media that I'm on. All of these I go live on. So there's Facebook, there's Telegram, this is Patreon, this is YouTube, this is Rumble, and that's X. Okay. Patreon, if you want it, that, boom, right there. Or you can click down here. Okay. This gets you signed up on Patreon. Now, for those that like to help support through the snail mail, you can send that over to the office. The new address there is Suite G, as in golf. Moved from Suite C, Charlie, to Suite G, golf. Nice. Guess the news is Trump won the caucus with 53% in Iowa. So, anyways, yeah, if you want to send through snail mail any kind of support, this is the address right here, 6477 West Fairview Avenue, Suite G, Boise, Idaho 83704. Send that to me. Postal money orders, regular money orders, cash wrapped aluminum foil, gold and silver coinage. All of that's accepted in support of what I do for free here. So, greatly appreciate those that have donated. And those of you that are on Patreon, Tier 1 and Tier 2, thank you for your support here. And then, obviously, Tier 3 for Wednesday night workshop, and Tier 4 for those one-on-ones. Again, I will reiterate that that everything to do with Patreon goes through Patreon. Nowhere else. There's private messaging through Patreon, so when you join Tier 3 or Tier 4, I send that information in a private message through Patreon, not an email. Through Patreon. It has its own internal messaging part. So if you want to communicate with me regarding Patreon, make sure that you're communicating with me through Patreon. Okay? Unless I've specifically given you permission to contact me any other way. Which there's a couple of people that I have, given what we're working on. So, and then I want to remind people, again, Thursday night every Thursday night. It's the same stuff, just like Wednesday night workshop. It's the same every Wednesday night. Okay? National Assembly, national-assembly.net, Thursday night calls. Here's your conference call info tab. There's the link right here. Now, if you install the free conference call app on your smartphone, once you click on this once, it'll be saved in your app on your phone. You won't have to come back here every time. Same thing with your desktop computer. Okay, and if you need, here's tutorial videos on YouTube if you want to install it on your phone and need some help. If you want to do it on your desktop, I have it on both. Works great. I love it. Way better than trying to dial in. But if you're one of those ones that just, you don't have a smartphone, you can call in right there. And then just make sure that you're muted. This seems to be a hard time for people to grasp. Decorum. If you're not acknowledged for speaking or trying to speak, mute yourself. Stay muted. We don't want to hear the stuff in the background of what you got cooking in the kitchen there, or whatever your private, or supposed to be a private conversation with your wife or your daughter or your son or whatever. Mute yourselves over there, folks. It's called decorum. Okay? Right? Way back to Abel Danger days. And even before that, brother. I've been out here since 2007, September of 2017, doing lives started on Facebook and then YouTube. And a year and a half on Blog Talk Radio before that. So, remember that the first part of this call on Thursday nights is the business side. And then it gets turned over to the educational side. Okay? And Bill's been doing a great job out there. I love you, Bill. I love your stuff, brother. And Jason from his Hardline. Here's some of his stuff right here. Click on that tab. Oh, is it? Uh-oh. Maybe it's having a hard time. Okay, here we go. And then, of course, here you go. State national fraud. I already covered this, and Destry put it out here. Right here. Here's all the verbiage. Again, here's your citizens. Okay, Section 212, citizen, are members of the civil society who are bound. And you go read Article 6, Clause 3, which is right here. The senators, representatives before mentioned, and the members of the several state legislatures and all executive and judicial office, both the United States and of the several states, shall be bound. That's what makes them the citizens. The inhabitants, as distinguished from citizens, are foreigners. Right. Why are they foreigners? Because they're supposed to be free and independent of government. We're not bound by the Constitution, and we're not subject to its authority, because we're inhabitants, not the members who are bound by the Constitution. It's the way our founders set up our form of government. Oh, that's sovereign citizen. No, that's sovereign people, sovereign inhabitants, sovereign man. I know a lot of people have a hard time using that word, man. or woo man, man with a womb. Can you define a woman? Yeah, it's man with a womb. It's in the word. Woo man, man with womb. How hard is it to say that? That's what a woo man is. Womb man, man with a womb. Used for procreation. And all them other genders are straight from Uranus. Whole nother planet away. And see, here, even in the Ars Confederation, the free inhabitants. Paupers, vagabonds, and fugitives from justice accepted. Where did these people get these words? What do these words mean? At the time. Not what the Roman civil law says. What the Ars Confederations mean as it is written. At the time it was written. Where did they pull this from? From the Law of Nations. And that's the point I was making last Thursday on Thursday night's call. Clinton was pointing out the Roman civil law, the code. Well, the code says, the Code of Federal Regulations says, well, that's the problem. What's the choice of law here? I'm going to go with the Law of Nations and the Constitution. Clinton wants to go with Roman civil law, the code. This has been the fight for the test of time, folks. And it's time to learn real law, not Roman civil law, the code, because that doesn't belong here. That's not part of our form of government. It's foreign jurisdiction. It's foreign law. Doesn't belong in our republic. And again, our founders created a one-of-a-kind form of government, a capitalist confederate republic. That's what they created. I didn't write it. They did. They created it. Okay? It's not a constitutional republic. It's not a representative democracy. It's not a democracy. It's a confederate republic. Articles of Confederation. Preamble to the Constitution for the United States of America. In order to form a more perfect union. Union. That's a league of friendship. A confederacy. Oh, that's right. A confederate republic. You're welcome, Dolores. Tiger out there, Tigger. You're very welcome. All right, folks. Have a wonderful night. And we'll catch you on the flip side. And we'll see those of you in Patreon Wednesday night. And again, I want to remind people that... Okay, so it's 43 and 45 at Federalist Papers. Okay, try to remember that. I thought you had said 6 and 9 or something, 3 and 5 or whatever before. But, yeah, Wednesday night, workshop. I'm going to be going into my case. I'm going to be going over the paperwork and the steps that I took. So, if people want to learn from the beginning on this, and it's not over, right? I mean, technically speaking, the case itself basically is coming to an end. February 2nd, supposedly I'm going to get sentenced. And then it's my turn. And that's where things are really going to kick off. And again, the long game, folks. What I'm doing is going to have an effect on everybody in Idaho, for damn sure. and more than likely have an effect on the whole entire nation called America here. Once I expose this Roman civil law, the code, and go to Congress with this, the game's over. The gig is up. Okay? Time to get back to Law of Nations, which is in the Constitution itself, Article 1, Section 8, that Congress has the authority to enforce the Law of Nations. Imagine that. And the laws of nature and the common law. That's the real law here in America. Even in England, it's supposed to be the common law. The laws of nature. Oh, and the law of nations. That's right. Even England's had its rough time with the Roman civil law, the code. And Blackstone highlights that in there, in the commentaries. So, again, have a wonderful night, folks. Stay safe out there. Enjoy your time off or anything if you get weather interrupting. Otherwise, be safe out there, folks. I know those of you in the nice, warmer states and stuff, have a good time. But those of us in the northern states, Canada, yeah, we're getting bombarded with snow. All East Coast, West Coast to East Coast, all the northern stuff is getting just bombarded. So pray for us and those that are out there, and obviously pray for everybody. Pray for our nation. Pray for worldwide peace. But we're at war. Peace will come eventually, but we got to win the war, folks. So God bless. Have a wonderful night, and we'll see those in Patreon Wednesday night, and the rest of you. Thursday night call. National Assembly call. Get on there, folks. Get connected with your states. Okay? Other than that, we'll see you next Monday night.